Good afternoon, everyone. My name is Chris Pon, and I'm the VP of Fund Development at ALS Canada. Before I begin, I wanted to take a moment to acknowledge the powerful video we just watched, featuring the voices from our ALS community. The stories remind us of why we're here today and the importance of the work we're doing together. ALS is a cause that is close to my heart. I'm a fellow community member as my dad passed away from ALS in 2021. As many of you know, ALS Canada's vision is a world free of ALS, and we are determined to transform the reality of this disease. We work with the ALS community to improve the lives of Canadians affected by ALS through advancing research, care, advocacy, and knowledge. So I thank you all for joining us today for our Will Planning 101 webinar. Having a will is essential, yet it's often a task that many people put off or avoid. A will ensures that your loved ones are taken care of and your wishes are honored. We're excited to have you to join us today and hope the insights we share with you will be valuable as you begin navigating this important process. Before I start, let's go through some housekeeping items. The webinar is going to be recorded and will be shared with you. There'll be a Q&A at the end of the webinar, but if you have any questions, feel free to put them in the chat and we'll get to them during that session, part of the session. And we'll share the presentation with you after. So please don't feel that you have to take copious notes during the presentation. So with that said, I'm pleased to introduce our guest speaker, Jandy John. Jandy is the Director of Estates and Trusts at Concentra Trust, Equitable Bank. And with that, I will pass it over to you now, Jandy.
Oh, thank you so much. It's an honor to be here. And I will pull up my presentation. Forgive me if I'm clunky with Zoom. I am trying my best. So give me 1 second. I'll share my screen with you. Okay, can everyone see my screen? Just thumbs up would be great. Yeah. Okay, so thanks for joining us today. Today we're talking about estate planning with me, Jandy John, and it's an honor to be here. So we did have some pre-questions, and I hope to answer in the presentation. If not answered, I'll get to them at the back end of the presentation in question period. So that's why, please be advised that this presentation is for information purposes and not intended to be legal or tax advice. So with that, we can move ahead. So what we want to talk about today in estate planning, we can't talk about it without talking about wills. So today, let's talk about wills, the importance of having a will in place, and how to give your last wishes after death. A will identify an executor to carry out the last wishes of the will maker. So being an executor, what it means to be an executor, the importance of having an executor, and the consideration for appointing an executor. And finally, the importance of having an estate plan. Estate planning includes wills, power of attorneys for finance, power of attorney for personal care, and if applicable, what trust structures should be in place. So let's get started. And first, we want to start with a quiz. So what percentage of Canadians do not have wills in place? So A, 28%, 38%, 48%, 58%, or none of the above. And the poll will come up. You can populate your answer. Okay. Not seeing a lot of population. Maybe I'm not seeing it correctly. So we'll go on to the answer. Okay, we'll go on to the answer. I'm not seeing it being populated.
So Jandy, just to let you know, 58% was the most popular answer.
Perfect. Okay. So we went high. So it's 48% of Canadians do not have wills in place. And of the 52% of Canadians with wills, 13% are outdated. And I do recommend to look at your wills every 3 to 5 years, or when something life-changing is happening. Like for instance, the birth of a child, the passing of a spouse, divorces, moving to another province, moving to another country. Those are significant life impacts that may want us to change our wills and update our wills. So let's talk about wills and estate planning. So why are wills important, and why are wills a part of our estate planning? So the will is the last word to provide direction after death. And I'm not going to go through every point on the screen. I want to focus in on a few of them. A will allows the ability to select an executor. And I will talk more about the executor in the next section and the importance of having the right executor selected. When a will is in place, it gives the ability to direct who gets the assets upon death. If there is no will, the assets are distributed in accordance to what we call the laws of intestacy. For example, we had a gentleman who was moving provinces, and within his move, he did not complete his move. He unfortunately passed away, but he was putting off writing a will throughout the process. So unfortunately, when he passed away with no siblings, no spouse, no children, and no parents, and he did not leave a will behind. And because of this, the laws of intestacy had to apply, which mean his estate went completely to a second uncle, remote uncle living in the UK. The laws of intestacy dictates who gets the estate if there's no surviving spouse and family members. So his estate went directly to a distant uncle in the UK, someone he did not even know. He was 95 years old. But this gentleman also had a lot of friends. He had pets, and he was very trouble-minded. So he did not get the opportunity to leave his legacy to where he wanted to direct. So that's one of the importance of having a will. It directs you where you want the legacies to go to. The will overall is the final voice of the will maker. If the deceased left behind minor children, the will directs who to be guardian for those minor children. And in Ontario specific, there's an ability to have a primary will and a secondary will. The primary will is probated, which means that it goes through the format, and the secondary will is completely private. So if the will maker had private shares or companies or holdcos, and they can differentiate and reduce some probate costs by having primaries and secondary wills. But I would encourage everyone to talk to their will preparer to ensure what can go into primary or what can go into secondary. It's all a part of the planning itself. So now we talk about wills and the importance of wills. We can move on to estate administration, what it looks like. And for this, I have another question to ask the audience. So how many tasks are there to complete an estate administration? And is it 150 to 99, 200 to 249, 250 to 299, or over 300? We'll see your votes. And I can't see the filling, so if someone can tell me the
I will
vote.
let you know, Jandy.
Perfect, thank you.
So there's a couple coming in, but it looks like the majority has said 200 to 249.
Okay, perfect. So I'll put the answer up for everyone. Okay, so here, for a simple estate, it can take over 270 individual tasks to complete an administration. and up to 3 years to fully pay out the funds of an estate. Estate administration is not something that goes in lightly. There's a lot of different tasks to complete. And if you see from this slide, this is an example of an estate administration checklist. Please forgive me, I saw this morning, I gave you page 1 of 2 twice. There are 2 pages to the checklist. High-level tasks are on the checklist, and each of these high-level tasks have different subtasks, from the first step to locating the original will to the last step of receiving final clearance from the agency. It can take over 270 individual steps to get from A to Z in estate administration. Just on a side note to everyone, please do not leave original wills in safe to deposit boxes. And you can ask that question why afterwards. We will move on. And just a note to the side to everyone. So let's move on now to being an executor. One of the first decisions the will maker has to make when preparing a will is who will settle the estate. Who will be my executor? So let's move into the executor role. And the will maker selects who they want to sell the estate, i.e. the executor. Being an executor is a full-time commitment. Therefore, careful thought and consideration should be given when selecting an executor. An executor can be an individual, or an executor can be a professional executor, like myself, a Concentra Trust. Not me personally, the trust company. So what is an executor? The definition of an executor is a person or professional named in the will and administer the assets of the deceased persons in accordance to the wishes as outlined in their wills. The executor has all of the liabilities associated with the estate settlement, like paying the taxes, ensuring all claims to the estates are paid, not over-distributed, and is accountable to the beneficiaries. For example, if the executor did not discover all of the liabilities of the estate and paid out the estate, and later on a liability was discovered, that executor is personally responsible and liable to ensure that liability is paid. The executor must also report to the beneficiaries, and the beneficiaries can challenge any decision the executor makes. Overall, the executor must maintain transparency throughout the process and communicate with the beneficiaries. Most conflicts arise due to lack of communication. For example, if the beneficiaries do not receive statements showing expenses paid to the estate, they can really challenge the executor, go to court, sue the executor, and I would say 8 out of 10 times they'll probably win the case, and that executor will be held liable and have to pay out of pocket for the charges. So what do you need to consider when looking for an executor? So let's look at some consideration. We have good traits. So has the person been declared? So the person you're looking at to be executor, have they ever declared bankrupt? Are they trustworthy to complete the wishes as outlined in the will? Is the person of age to be executor? Is the person older than the will maker? Should also be considered. Given that if the executor becomes incapacitated or dies before the estate is settled, that estate is now left in limbo to be administered. Also consider residency. Do they live in the same province? Because living out of province or out of country adds a different level of complexity to an estate. Consider existing dynamics. Is the person going to be selected? Will they add conflict to the remaining family members? For example, if siblings and families do not get along while the will maker is alive, I can guarantee you they will not get along when the will maker passes away. So if family members are appointed, ensure there is always conversations between the family. We spoke about personal liabilities to the executor and the length of time commitment to complete estate administration. Therefore, choose executors who have the time to commit to it and who will carry out the job in a time-efficient and cost-effective way. So let's go with the challenges of being an executor. An executor, again, overall has the overall responsibility to settle an estate in a timely manner, cost-effective, and report to beneficiaries. And to ensure all liabilities are paid, and I do emphasize that because liabilities, again, to an estate, if not done correctly, will come back 2 and 3 years later. For example, let's talk about an executor. Let's call her Sue. Sue's a family friend and agreed to settle her estate, her friend's estate. Because Sue was a friend, she did approach the estate settlement casually and did not report to the beneficiary and made payment to creditors without verification of those liabilities. It ended up that the beneficiaries ended up suing Sue, and Sue had to reimburse over $20,000 to the estate, plus the legal costs of the beneficiaries. So when an executor, when a beneficiary challenges the executor must account to all of the beneficiaries. And again, I will continue to say it's not a job that we take lightly. It is a full-time commitment, and it does take care and consideration when you're working with someone else's inheritance and someone else's money. So, being named an executor, sometimes people think that it's an honor to be named an executor. And I put myself into this category because I've been doing this role for many years. And I've said to every family member of mine, please do not name me as an executor because I am going to be the worst beneficiary you've ever seen. And the role of an executor takes up too much time, and I have a full-time job already. So adding an executor, ensure that they have the commitment to do it. There are complications and expectations of being an executor. So the role that you're appointing should not be taken lightly, and the person receiving that role should not take that role lightly either. It is a full-time commitment. It comes with a lot of responsibilities. It comes with a lot of different moving parts. You're almost like a project manager to ensure that the project is completed in a timely, cost-effective manner, and all of the participants in the completion of the project are happy and will release you from those duties at the end of the day. So let's go to other types of liabilities of being an executor. So we had a question about probate. So let me define probate in this capacity, and then we can go through it. So probate is a timestamp for liabilities. Probate in Ontario is approximately 1.5% of the estate value. So probate is the court granting authority that the will is the last will and testament. Some may create planning in their lifetime to reduce the cost of probate. For example, which I do not recommend, as it adds complexity to who owns assets, is making assets joint. One of the most problematic things I see in the state administration is joint assets. The danger of making asset joint is it opens individual assets for claim. If the joint assets owner has a claim against them, that opens the claim. And ownership, who really owns that and who's paying the taxes and those joint assets. There's also a way of creating trust in your lifetime to manage to mediate some of the cost of paying that 1.5% of probate. Assets in trust are private, and they do not fall into the probate because a probate is public and public assets. But there are advantages and disadvantages of creating trust. Is the cost of the trust while alive greater or less than the cost of what probate would cost? So those are considerations also. So let's talk to your advisor, talk to your lawyer to determine if creating a trust is an option. Other liability to executor. If the executor did not apply for probate, it leaves the estate permanently open for claims against the estate. For example, someone may come forth after death with a claim against the estate. When probate is obtained, an advertisement to creditors was posted. Any claim after 6 months after probate would not be considered. So probate is really that timestamp and that authorization. So it protects against claim against the estate, and it gives that name of the executor, and it says this the last will. Another example is someone may come forth after the estate is administered and said, hey, I found a will that was dated 2 years later than the will you used. And that if that will was never probate, that estate should not have been administered in accordance to that earlier will. So think about probate as a protection as an insurance, but there are ways to minimize that 1.5%. So I would encourage everyone, talk to their lawyer, talk to the advisors if they do have advisors, or talk to and get information what's the best option to mitigate some of the probate costs and to also ensure you get that timestamp and that validity of the will, what that probate costs. Another example is with CRA, Canada Revenue Agency. Executors should always apply to CRA to get that final clearance certificate. This is again the stamp from CRA has received all the taxes owing. So without the clearance certificate, CRA can always reassess tax returns and apply for most taxes. And I've seen that in my experience too, where we thought estate was settled. And CRA came back a year later, said they did assessment, held up the paper. CRA, you did your final clearance. Here it is. So ensuring that all tasks are completed and ensuring that all beneficiaries release the executor of what the role of executor. So we talked about the major considerations. So when the will maker names the executor, does that mean the executor has to act? It doesn't. You can name it, the will maker names the executor, it doesn't mean they have to accept the roles. For example, if my sister named me as executor, albeit already told her, do not name me, at the time of to act, when my sister passes away, I can say, no, I am not accepting the role as executor. Therefore, someone else will have to act. That's why I do recommend the will maker names an alternate executor. If there is not an executor to act, the laws of intestacy will again apply, and family members alive will have the opportunity to act. Therefore, it's important that an executor and the alternate executor are named in the will. And in this is where professional executors can also play a role. I go back to this first example I told you about that gentleman who passed away with the great uncle. That great uncle would have to give his approval and consent for anyone to act, any of his friends to act in Canada, because he's the last remaining relative, and that's the laws of intestacy that gives him the authorization to consent to who acts as executor. So let's go into a case study for consideration for executor, because sometimes I feel like storytelling tells the story to open it more. Let's talk about Frank and his consideration. So about Frank, Frank's spouse recently passed away. He's looking to update his will. He has two adult children. They both have careers. Lives outside the country. Frank is estranged from his children are estranged from each other, but Frank is very close to his children. He does have an older brother. So when Frank is naming his executor, what should Frank consider? He should consider availability. Does his family have the time to settle the estate? Consider residency of his children. One lives in the US. Can his son works together and be objective, or can he name one son over the other? Frank wants to be fair and equal to his son, but at times you can't always be fair and equal. He may want to consider naming his older brother and consider his brother is older than him and may become incompetent or dies during the estate administration. So this is everything that Frank has to consider. In most cases, an individual executor does make the most sense. For example, if I am the named beneficiary, I can be the named beneficiary because I'm the only one entitled to that estate. So I can take as long as I want to settle and I can move I don't have to release myself. However, there are instances when professional executor is more appropriate, like in Frank's situation. We never want to dismiss the emotional connections to estate administration. There's grief versus being neutral versus being professional. So if there's no family members or friends in the same province, it will add tax complexities to estate administration. If there's complex family dynamics, like in Frank's situation where his children do not get along, he has an older brother. And even if there's a blended family situation, then it makes sense to add someone, a third party, neutral party. In Frank's situation, he appointed his brother and a trust company as an alternate executor. So should his brother become incompetent, or if his brother cannot act, then the professional executor will take over to settle the estate. So it's an insurance in terms of his brother having the capacity to complete the estate administration. So what would be the benefits of having that professional executor in place? Professional executor will bring expertise, they reduce costs, and they do manage the liabilities of being an executor. Professional executors, trust companies do not age or become incompetent, so they'll always be there to continue a continuation. And professional executors also take away the burden of administration away from family and allow them the time to grieve. Frank could have named the professional executor in one of three capacities. Name a professional to act alone instead of a family member, act together with the family member, or alternate to a family member. Ultimately, Frank chose what was best for his family, and he chose that his brother should settle the estate with and giving him an insurance policy by having a professional executor as an alternate in case his brother is not able to act. And that will retain the family so the sons can have their time to grieve, and the sons will have a confidence in knowing that the estate will be settled and they'll be reported to, and they will have the time they need with their family members. So let's move into the importance of estate planning now, and then we can do a wrap up and open for questions. So estate planning is more than just having a will in place. The first rule of thumb is when appointing someone, let the person know they're being appointed, whether it's a power of attorney for financial care or for personal care. Consider what kind of legacies you want to leave behind, like charitable gifts, establishing gifts for grandchildren, children with disability. This cannot be done without proper directions in place. Select the right person to manage your affairs. Is that person trustworthy? Will they take advantage of situation when I'm not competent to do so, or when I pass away? We spend a lot of time talking about executive roles and responsibilities to ensure that the person is a professional, select is aware and prepared to act at the time. We want to think about the beneficial gifts also. Do we want beneficial gifts to happen in our lifetime or upon death? And think about those gifts. For example, do you want to leave 15 small gifts or one or two larger gifts that's more impactful or to an organization or to a particular cause? So a will plan is in really thinking out what do I want to do with this legacy and where do I want to leave this legacy behind? Am I charitable minded? Where do I want the impact to be? And making sure that it's impactful and how I want it to be, whether it be causes or organizations. So we started with the slide. I want to conclude with the slide also. Estate planning. Estate planning overall allows for the individual wishes to be carried out while alive by power of attorneys, by trust, and if when they become incompetent to manage the personal affairs, and when they pass away under their will. The only thing guaranteed is in life is death. And if there's no plan or direction in place, the individual's legacies can be paid to remote individuals not known to the will maker. So the most common mistake, the number one mistake of estate planning is not having a plan in place. And we know oftentimes we don't want to think about death, or we don't want to think about what happens at death. But the gift you can give to your family that you're leaving behind is to make sure that there's something in place that they can follow through on and ensure that your legacy is taken care of and is managed after death. So in summary, it is important to put the plan in place. It allows for the individual to direct where their legacy goes, whether it's to a family, whether it's to charities, organizations, or even to passion projects. Consider your power of attorney and wills. Power of attorney is important when an individual loses capacity, and the will is the final voice after death. And trust planning is also very important if it is cost efficient and it makes sense within your resources at the time. So for really good planning, I would recommend you talk to a competent lawyer and an accountant to ensure that the tax consequences are beneficial to the planning that we do. And this is your Concentra Trust team. And we move on if you have any questions. And we have our disclaimer, which I paraphrase at the very beginning. So these are the questions that were presented at the beginning. I think I covered them all. So let me just go through them quickly. And if they want to be needed to be expanded upon, please add them in the Q&A. Best practice for bequeathing home to family members. Again, depending on who the family members are, and the home, whether the home is principal residence or rental property. So there's a lot of unpacking to do there, depending on the home and the family member. If we're assuming it's a principal residence, it's beneficial to register the home that it rolls to the surviving spouse upon death. And if it's going to one child, but also think about if the recipient of that home is on any ODSP or any benefits, because the consequences also what you need to own. So it's a question, but it's a really broad question to answer. Charitable bequests, consider whether you want to leave them in your lifetime or whether you want to leave them upon death, because there are different tax consequences that can be leveraged in your lifetime and upon death. So speaking to your accountant and financial advisors to see what is the best route to leave your charitable gifts behind. Like to more about I would like to learn more about probate, what it is and how to avoid it. Okay, I said never avoid probate. I know that's easy to say for the cost of it, but probate is more than just the going to court and getting that and having the court approve the will. It leaves for wide open in terms of an insurance policy. For creditors, it's an insurance policy to say this is the last will and testament, and you can do some planning in your lifetime to reduce probate. If you have significant assets or business owners, there's ways to plan out. A lot of people use joint assets. I am not a big fan of joint assets unless it's between spouses, because again, it's the ownership of the assets. And if somebody declares bankruptcy or if somebody takes that assets away, we see a lot of elder abuse in the line of work I do. So I'm not a big fan of joint assets ownership. Um, Question 4, in Canada, can a trust be set up to avoid probate? Most definitely, but when setting up a trust, consider the cost of the trust setup as opposed to the 1.5% of paying for probate. Is there any way to avoid probate? Oh boy, I don't like to avoid probate because I know there's beneficial use of probate, but there's ways to bring down probate in Ontario. Are wills prepared via will kit legal? They're all legal, and in some instances, will kit wills are viable and can be used. But in situations, I see in terms of will kits, it makes a lot more sense to go see a lawyer and a drafting lawyer to ensure you get the advice also that when you put in your wills together, because advice is fundamental when putting your documents together. Okay, I'll turn it over to questions.
So Jandy, I have some questions from the audience here. They're enthusiastic and thank you for your presentation. So the first one is, what is the cost to have a trust company execute a will?
Okay. So the trust company, there's 2 steps to the will process. One is the lawyer drafting the will, and a lawyer's fee can be between 200 to 1,500 depending on the planning. So that's the first. If you name a trust company to administer the estate, an executor can charge up to 5%. So even if you name a neighbor, that neighbor can charge up to 5%. Trust companies tend to charge significantly lower because they administer on a greater scale. So it's between 4.2, it's between 1% to 4.25, depending on the asset value.
Perfect. Thank you, Jandy. So another question for you. What are some common mistakes people make when writing their wills?
Oh, Not, there are so many. The first one is not not really understanding the family dynamics. Like if I have siblings and I know my sibling, like for instance, I have two children. If I know my two children do not get along, I am not putting them to act together as because that will just cost a lot of money. If I know that I don't, if I know that I have all my registered plans with designated beneficiaries, I am not gonna do a will that leaves assets inside my will because all of the taxes payable is going to come from my estate. There are a lot of different mistakes that can be made. It's a whole gambit. Call me, I'll go through them with the person who wants to know.
Okay, perfect. I think you briefly touched on this before. Are there tax advantages to leaving a gift to charity through your estate?
Correct. Yes. It's a tax savings to leave an gift to your estate.
Okay. Can you talk about the importance of sharing your legal or your legacy plans with family or executors?
Yes, they need to understand, right? They need to understand what your intentions are and how you want things to happen. I've seen many examples of when they have to eventually come to trust companies because the executor was not aware of what they wanted to happen. And the will was poorly drafted that didn't give an outline of what was needed. So the executor is trying to piece things together and not understanding like it is. So communicating with everyone so they know what to expect. You know the book What to Expect When I'm Pregnant? It's the same thing. What should the family be expecting when I pass away? They should know I appointed Joe to be my executor, so they all have confidence in Joe. I'll understand who Joe is, and they understand that this is where I want my legacy to go. I want my children, I'll gift my children in their lifetime, and I want it to go to charity upon death because you have been gifted in your lifetime. So there's no need to challenge this will because I'm going to gift you outside of the estate. So it's just to really understand why the decisions are made in your wills.
Perfect. Jandy, I'm gonna have you answer one of your questions you
Sure.
asked. So you never answered. Why not keep a will in a safety deposit box?
Yes, this is one of the banes of my existence in estate administration. To access a safety deposit box, you have to prove you're the executor. You can only prove you're the executor if you have the original will. So it's like the chicken and the egg. If you can't get into that safety deposit box, you can't pull the will to say, I am the executor and this is the will. So that's the consequence. It's the chicken and the egg because you can't get access to it, and you can't get access to it because the banks are not going to allow you to access it because you can't identify who you are.
That makes total
Yeah.
sense. So I have one last question for now. So can co-executors be a good idea to spread the work among children, assuming they get along? Can three siblings be named?
They can be named, but think about three different mindsets, and executors have to agree to everything. If the family member gets along and they're all in the same location, it makes sense for all three of them to be named. If they live in different provinces, that adds that I have to wait for this person to sign and this person to sign. Imagine selling a house with three people have to approve, have to come together and sign off on everything. So that's where it become complicated. Two, if they live in the same region and they speak the same language, it makes sense, and they know ahead of time the three of us are the executors, so they can work together. If they don't know, or if one of them live outside of province, it adds another layer of complication. For family members that have family members outside of the province, outside the country, and they can't be named as executors, I do tell them that enter in the will that they can be in an advisory role. So they're still a part of the giving advice, but they don't have to sign off on everything.
But Jandy, your safety deposit box is a popular question here. So someone asks, if not putting in a safety deposit box, where should an original be stored?
Um, One with the drafting lawyer, two with the executor, Those are the two places I would recommend. The executor and the drafting lawyer, and the executor should have like a fireproof safe in their home to hold the document.
Perfect, perfect. I think that's the end of questions there. I'd say to anyone who is on the webinar now, feel free to send us follow-up questions if you have any, and we can ask Jandy about them and get back to you. But I want to thank you all for spending your time with us today. We hope you found today's webinar insightful and inspiring. And thank you, Jandy, for sharing your knowledge with our team here. As I mentioned earlier, a survey link will be posted in chat for you to provide your feedback. Over the next couple days, keep an eye on your inbox. You'll receive an email with the presentation slides, a link to the recording, and we'll also include a link to the survey if you missed it here. And we'd love to hear your thoughts. So stay tuned for more details. We're going to have another webinar coming up during Make a Will month in November, and we hope to see you there. But we hope you gain some insightful knowledge here, and we look forward to you on our next call. So thank you, everyone, and have a great afternoon.
Thank you, everyone.
Bye-bye.